certain federal fraud and abuse laws, including the Anti-Kickback Statute, the Ethics in Patient or Physician Referrals Act, the Stark Act, Civil Monetary Penalties Law, the False Claims Act, and the report and repayment obligations. And we're going to end up by offering you some practical suggestions of what you need to do to comply. Some preliminaries here. Our written materials should include a copy of the PowerPoint slides, a copy of some articles that may be helpful, including an article I wrote on Stark and the anti-kickback, publication from the OIG designed to train physicians concerning the fraud and abuse laws, the OIG Supplemental Compliance Program Guidance. This compliance program guidance is actually for hospitals, but it really contains a good overview of the compliance principles and a discussion of the relevant statutes. We've also given you a copy of the CMS's proposed repayment rule that we'll talk about a little bit later. The written materials are available for download if you haven't received those. Also, this program will be recorded and available for download at our website. If you have questions during the program, we're probably not going to be able to take those because we've got a lot to cover today. But if you use the chat feature and send them to either Bill or me, or send it to us at our email addresses, we'll make sure that we respond to those offline. Few additional preliminaries. First, this is an overview of some of the relevant federal laws. We're not going to be able to go through all of them. We always remember that there's additional state laws that may apply. Most of your individual states have similar anti-kickback statutes, fee-splitting statutes, and those types of statutes that may also apply. We're not going to get into those, but just remember that you have to consider those when you're doing the evaluation. The application may depend upon your specific facts, and finally, we're going to be moving awfully fast. We've got a lot to cover today, and this is really designed just to give you kind of an overview of these laws. We've done separate programs on each of these laws last year, and if you would like to access those or the materials related to those are available for download on our website. With that said, by way of preliminary comments, let's talk about the fraud and abuse laws. With the Affordable Care Act, the government realizes that it's going to cost it a ton of money, and therefore the government wants some of that money back. And because of that, the government has dramatically beefed up its fraud and abuse laws, including implementing additional rules for payment, increased enforcement mechanisms, increased penalties if you violate it, and most importantly, you now have an affirmative obligation to narc on yourself and report and repay overpayments that may result from, among other things, failure to comply with the laws that we're going to talk about today. First and foremost, let's talk about the Anti-Kickback Statute. The Anti-Kickback Statute says that you cannot knowingly and willfully offer, pay, solicit, or receive remuneration to induce referrals for items or services covered by government healthcare programs unless you fit within a regulatory safe harbor. That is incredibly broad. To make matters worse, the government has interpreted that, the courts have interpreted that to make it even broader. The Anti-Kickback Statute is violated if one purpose of that remuneration is to induce improper referrals, even if you have 99 other legitimate purposes for doing it. Now that's problematic because if you're doing a deal with a referral source, it's going to kind of create this presumption that of course you're doing that in order to get referrals. It's going to be difficult for you to disprove that intent to induce referrals was not one purpose, if not the sole purpose, of doing that kind of a deal. So you've got to be aware of your documentation, beware of that improper intent. Now it used to be, at least in the Ninth Circuit, that ignorance of the law was an excuse. The Affordable Care Act changed that. Ignorance of the law is no excuse. Doesn't matter whether you thought that what you were doing was legal. Doesn't matter whether you could do this same kind of deal in other industries besides healthcare. If you violate the Anti-Kickback Statute and one purpose was to induce those improper referrals, hey, that's a violation. What can happen? You can go to jail. The Anti-Kickback Statute is a criminal statute. In addition, you can get hit up with civil penalties because it's also a violation of the Civil Monetary Penalties Law. And in the wake of the Affordable Care Act, the Anti-Kickback violation is now automatically a False Claims Act violation, which means that you can get hit up with all the False Claims Act penalties that Bill is going to talk about in just a little bit. To make matters worse, because the False Claims Act is a civil case, it's going to be subject to a lower standard of proof than an anti-kickback criminal case, and therefore it's going to make it easier for the government to go after you. Because it's a violation of the False Claims Act, you could also be subject to key TAM suits, like Bill will probably talk about in just a little bit. The OIG has indicated that if you do have an anti-kickback problem and you go do the self-disclosure, the minimum, I mean, this is if you just narc on yourself, you go hat in hand and say, hey, I'm sorry, the minimum settlement will be $50,000, and it could be substantially more. Because of the breadth of the anti-kickback statute, anytime you want to give anything to induce or reward referrals or do any deal with a referral source involving referrals for government health care programs, you've got to be concerned about the anti-kickback statute. I like this cartoon. I think it kind of summarizes. The Albonians, let's not say the Albonians. How about the specialists? The specialists are demanding bribes or else they won't do business with us. Well, hire them as overpaid consultants and don't ask them for anything. That way it's all legal, right? And by legal, you mean won't get caught. Potato, potato, what's the difference? Well, as the people in USB Anderson found out, there's a big difference. In this situation, the hospital paid 2 physicians to come in there and serve as co-directors or consultants of their geriatric department. But what did they do in exchange for the $75,000 a year payment? Not a whole lot. At least that's what the government argued. They said that that payment that they were getting was really to induce referrals. As a result, physicians went to jail. The hospital CEO went to jail. The CFO was originally acquitted, but that acquittal was reversed. The only good news was the hospital attorney got off. So, the anti-kickback statute, it applies, as that case shows, it applies to anyone who solicits, receives, offers or pays with the intent to induce or reward referrals for federal program business. It can apply to providers, vendors, management at your facility, marketing personnel. It can apply to patients. Patients are referral sources. They may refer themselves or somebody else. Attorneys or anybody else. Note that it applies to both sides of the transaction. So it's not just the hospital or facility that's paying for these referrals that can go to jail. It's also the physicians or others who are seeking to induce or solicit or receiving payments. They can also go to jail. It applies to any form of remuneration. That means anything of value. It could be money. It could be free or discounted items or services like perks, gifts, insurance, trips, free CME, anything like that. It could be overpayments or underpayments. You overpay a physician for what they're doing, so it's above fair market value, or maybe you're charging a physician less than fair market value for rent. Payments if no items or services are provided or required, or payments for items or services that are not necessary. You really don't need the service, but you wanted to just funnel money to that particular physician, so you're going to go ahead and pay them, and you'll think you'll be safe doing that. No, not necessarily the case. It applies to waivers or co-pays of deductibles because that may be used as incentive to induce patients to come to you. Low interest loans, business opportunities, anything else of value. It is incredibly broad. Now, technically, the anti-kickback statute only applies to referrals for items or services that are covered by federal health care programs. So some clients will say, well, we know what we'll do. We'll just pay them, but we'll only pay them for, or we'll carve out the non-Medicare, Medicaid stuff, so we're not going to make any payments for that. The government recently said in an advisory opinion that, hey, we really don't like that either because we understand that if you're really trying to carve this stuff out, but you're paying them for the non-government referrals, then they're also going to send the government referrals to you, and therefore you're really paying for the government referrals, and therefore it's a violation of the anti-kickback statute. Note that this is a federal statute. Many state anti-kickback statutes are not so limited. They may apply to any payer source, or they may also apply to government health care programs, so you got to be aware of the scope of your state anti-kickback statutes or fee-splitting statutes. Some common problems you may see out there. If you see these situations, there ought to be red flags. These aren't all of them, but there's some of them. Paying providers more than fair market value for their services, charging providers less than fair market value for the items or services, paying providers for items or services you really don't need, giving professional courtesies to referring providers, allowing referring providers to use space or equipment for free, joint ventures with referring providers, free items or services to patients who are Medicare or Medicaid beneficiaries, waiving co-pays and deductibles for beneficiaries, and so forth. Now, those are just some of the problems. Now, Because the anti-kickback statute is so broad, the government has said, well, we'll give you some safe harbors. There is no liability if you structure your deal to fit within all the requirements of a safe harbor, but you got to fit within all of them. Now, you're not required to fit within the safe harbor, since the ultimate question is whether or not you've got that improper intent to induce referrals. But you're safer if you fit within the safe harbor. You're safe if you fit within the safe harbor, and you're safer the closer you come to fitting within a safe harbor. There are safe harbors for all sorts of things like employment contracts, independent contractors, agreements, leases, sale of practice, recruitment agreements, and so forth. But each one of those has very specific conditions that have to be satisfied to fit within the safe harbor. So if you want to do a deal, and you think that there's anti-kickback implications, you're going to want to open up and make sure that you can structure the deal to fit within a safe harbor. If you're not, then just realize that you're in dangerous waters. Now, some people say, well, it's only a little violation. We're just giving a little kickback. There is no de minimis safe harbor. But, as a practical matter, if you just happen to give away a pen, probably the government's not going to waste resources going after you, but the government has specifically declined to impose a de minimis safe harbor under the anti-kickback statute. You can avoid the anti-kickback statute if you can convince the government that the deal did not result in substantial risk of federal program abuse, either because of the nature of the transaction or you incorporate certain safeguards, but you probably don't know whether or not that's going to fly unless you get an advisory opinion like we'll talk about in just a minute. There is no fair market value safe harbor. Just because you pay fair market value does not necessarily mean that you're safe if there is improper intent. Now, fair market value is very important, and usually you're going to be okay if you document fair market value and a legitimate reason for what you're doing it, and you have in place appropriate safeguards. But just because you pay fair market value, that does not necessarily mean you're safe. You have to satisfy the other conditions that are in those safe harbors. Now, the government has set up a process that if you want to do a deal, but you're concerned about the anti-kickback, you don't fit within a safe harbor, you can go to the government and ask for an advisory opinion in advance, and they will tell you whether or not they think it's going to violate the statute. The government posts its advisory opinions on its website. Now, the posted advisory opinions are not binding on anyone other than the participants to the opinion, but if you structure your deal to fit within one of those approved advisory opinions, then you're probably going to be safe, but there is no absolute guarantee. All right, those advisory opinions, you can access all of those at this government website. That is a very brief overview of the anti-kickback statute. Let's talk about its evil younger brother, the federal Stark Law, named after Representative Pete Stark from California. The Stark Law says that if a physician or their family member has a financial relationship with an entity, the physician may not refer patients to that entity for certain designated health services, and if the physician does improperly refer the patient, that other entity may not bill Medicare for such designated health services unless they structure the deal to fit within a regulatory safe harbor, a regulatory exception. A little bit of background helps you understand Stark. The government a few years ago, when physicians were looking ways to supplement their income, the government recognized that there was a sharp increase in the number of MRIs and diagnostic tests that were being ordered, and they wondered, why in the world is that going on? They did a study and concluded that the reason it was going on were these physicians were out there purchasing these practices, opening up their own labs and opening up their own imaging centers, and that created an incentive for them to refer patients there, causing increased cost to Medicare, and therefore Representative Stark and Congress came up with the Stark Law. Now, importantly, the Stark Law does not prohibit financial relationships with the physician or the referral source, the provider of DHS. It just says, hey, physician, yeah, you can have that financial relationship with the hospital or this other entity. It's just if you have that financial relationship, you can't make referrals for certain designated health services to that entity with which you have the financial relationship unless you structure the deal to fit within the safe harbor. And if you do so, hey, these are the penalties. Well, first, you can't get paid for those services that were provided per an improper referral, and that hospital can't bill for those services. And if they do bill for it, they've got to repay the amounts improperly received within 60 days. And if they fail to repay the amounts they received improperly, they can get hit up with an additional civil penalty of $15,000 per claim. That's not per deal, per transaction. That's per claim that was submitted. In addition, the physician gets hit up with a penalty of $100,000 for entering into a scheme to violate this. Also, Stark violations can frequently constitute anti-kickback violations, and they may trigger the False Claims Act and result in additional penalties like we'll talk about in a few minutes. Now, significantly, Stark says, hey, if you've got that improper referral relationship, the physician can't make referrals. That period of time that they can't make the referrals to that entity for designated health services is called the period of disallowance. That begins when you fall outside of compliance with Stark, and it only ends not when just you bring the deal back into compliance, but you also repay any of the amounts that are overpaid or underpaid. So you can't just correct it going forward and think you're good. You actually got to go back and repay any overpayments that have been made to the physician, or the physician would have to repay any underpayments in those types of situations in order to correct it going forward. Prospective compliance alone does not end that period of non-compliance. That's why it's important to consider, if you've got a Stark violation, doing the self-disclosure to cut off that liability. The penalties can add up very quickly. Just this year, in fact, on Tuesday, the Department of Justice issued this press release where a Florida hospital system had to pay the highest Stark penalty so far, $85 million. Why? According to the press release, the hospital executed contracts with 6 medical oncologists that provided an incentive bonus that improperly included the value of prescription drugs and tests that the oncologists ordered and that Halifax billed to Medicare. In addition, Halifax knowingly violated the Stark law by paying 3 neurosurgeons more than the fair market value of their work. They did the deals, but they didn't make sure that their deals satisfied the safe harbors. Now, some limitations on Stark. Stark only applies to referrals for certain types of services, not all services, only designated health services. Those designated health services are payable in whole or in part by Medicare or probably Medicaid. It includes inpatient and outpatient hospital services, outpatient prescription drugs, clinical labs, PT, OT, ST, radiology and certain imaging services, and certain other items. So it's not all services that are payable by Medicare or Medicaid, like the Anti-Kickback Statute. It's only certain designated health services. It also only applies to referrals by a physician, including MDs, DOs, etc. It's not for mid-levels. It's not for other providers. There may be anti-kickback issues with other providers, but Stark only applies to referrals by physician to entities with which the physician or a member of their family has a financial relationship. So if you've got a financial relationship with a physician's spouse, that physician can't make referrals over to you unless that transaction with the spouse were structured to fit within the Stark safe harbor. It applies to referrals by the physician for certain designated health services, and referrals is very broad. It's prescriptions, it's orders, it's just suggestions that they go get care someplace else. It's part of a plan of care. It's very broad, but it does not include services the physician personally performs. Stark does not apply if the physician is going to personally perform their services, but it will apply if somebody else is going to perform those services, including others within the physician's own practice. Stark also applies to even referrals within a physician's own practice, so you'd have to satisfy a Stark exception. Now, it applies to referrals by the physician to entities with which the physician or their family member has a financial relationship. That could be a direct or indirect relationship. It could be an ownership or investment or a compensation. It's anything of value could potentially create a financial relationship that would trigger Stark. Freebies, contracts, employment agreements, joint ventures, ownership interests, investment interests, loans, any of that type of stuff could potentially implicate Stark. Now, unlike the Anti-Kickback Statute, Stark is not intent-based. You either comply or you don't comply. There is no good faith compliance. There is no technical defect. You either comply or you don't comply. So to comply with Stark, the transaction must either fall outside the statute because there was no financial relationship or no referral, or you've got to structure the deal to fit within the regulatory safe harbor. There is a very limited exception, if a hospital receives a referral but they have no idea who the referral was from and no reason to know that that referral was prohibited, then the hospital could go ahead and bill for that. But that's a limited exception and certainly wouldn't apply in situations, most situations where you've the hospital's contracted specifically with a physician. So what are some common problems? Again, these are not all problems that you could come up with under STARK, but these are kind of red flag situations you got to be aware of. Situations where the physician referrals to entities that the physicians own. So that physician has its own MRI center someplace else in the city, and that physician's making referrals over there. Hey, that's STARK. Compensation arrangements, which pay physicians based on their referrals, including your group compensation arrangements that pay based on referrals. Paying physicians more than fair market value for needed services. Giving physicians discounts, freebies, or discounted items. Subsidizing physician practices. Financial arrangements without a written contract. Performing after a written contract has expired. So you had a written contract, but you let that contract lapse and you never went back and put in place a new contract. If you didn't, then, and STARK requires a written contract, then that would be a STARK violation. Leases that fail to satisfy lease safe harbors. For example, there's certain limitations on leases. You can't generally do per click or on demand, or shared space leasing or shared equipment leasing. Amending contracts within 1 year, that's just some examples of common STARK problems. Now, STARK does have safe harbors. If you structure the deal to fit within the safe harbor, you're going to be fine for purposes of STARK. Some of those safe harbors are applicable to both ownership or investment interests. Some are applicable only to ownership or only to compensation arrangements. There's no liability if you comply with all the requirements of an applicable safe harbor. But if you fail to comply with any of those requirements, then you can't rely on that safe harbor. Again, there is no quote-unquote technical compliance. You need only comply with one safe harbor for each financial relationship. Some of those exceptions are, for example, physician services that are rendered by others within the group, or referrals within the group for these in-office ancillary services. But in order to do that, you have to satisfy certain criteria, including you have to qualify as a group practice. There's other exceptions for rural providers. That's an important one. If you are in a rural area, STARK has an exception that allows physicians to make referrals to entities that they own. That doesn't apply in metropolitan statistical areas. There's a bunch of other exceptions, like for employment contracts, personal services contracts, leases, recruitment, retention, and so forth. You just need to make sure that you structure the deal to fit within all of those applicable requirements for a safe harbor. So, here's your STARK analysis. To determine whether or not STARK applies or you may have a problem, you have to ask yourself first, is there a financial relationship between the providers of designated health services and the physician or the physician's family member? It could be a direct or indirect relationship. It could be an ownership or investment interest. It could be a compensation arrangement. Remember, remuneration is very broad. Financial relationship is very broad. If there is a financial relationship, then you've got to ask yourself, does the physician make or has she made referrals to the entity for DHS that's payable by Medicare? If they do, hey, you potentially got problems. So then you would ask yourself, does a safe harbor apply? If it doesn't apply, chances are you violated STARK and you're going to have to do a repayment. The government has posted some helpful guidance on its website concerning STARK, including the government's website has things like advisory opinions, just like on the Anti-Kickback Statute. You can go to the government and get an advisory opinion for STARK matters, although there aren't as many for STARK. There's FAQs. There's a list of the designated health services that are listed by CPT code. It's not an exclusive list, but it is helpful in identifying whether or not a particular service is a prohibited designated health service. There's guidance concerning the self-referral disclosure protocol and recent settlements. All right, that is a brief overview of STARK. Let's talk now about the Civil Monetary Penalties Law. This is one that gets overlooked sometimes. The Civil Monetary Penalties Law is kind of like this catch-all law that they went through and they identified a whole bunch of misconduct and identified the civil monetary penalties that are going to apply to that conduct. Among other things, this law prohibits things like submitting false or fraudulent claims, providing kickbacks, offering inducements to program beneficiaries, or offering inducements to physicians to limit services. I'm going to come back and talk about those a little bit later. Submitting claims for services ordered by or contracted with an excluded entity, failing to report and repay an overpayment, or failing to grant the government timely access if they want to come in there and look at your books and evaluate whether or not you're you're complying with the law. What are the penalties? Well, depending upon the conduct involved, they could range anywhere from $2,000 to $50,000 fines. That can be per claim, per violation. In addition, you can get hit up with treble damages, denial of payment, repayment of the amounts that you were improperly paid. You can be excluded from participating in federal government programs. In addition, civil monetary penalty law violations also frequently constitute violations of the False Claims Act or the Anti-Kickback Statute of Stark. So you may be subject to Satan's trifecta. All of this comes down and they can rely on these other statutes to go after you. Let's talk about a couple of specific aspects of the CMP law that kind of get overlooked sometimes. The first is the CMP law says that you cannot offer or transfer remuneration to a Medicare or a state program beneficiaries if you know or should know that the remuneration is likely to influence the beneficiaries to order or receive items or services payable by federal or state programs from a particular provider. The government doesn't want you out there offering freebies to induce Medicare beneficiaries to get more services because they're just going to cost Medicare more money. What's the penalty? $10,000 for each item or service that you provide. You can also get hit up with treble damages, repayment of the amounts paid, and exclusion from Medicare or Medicaid. This provision applies if you know or should know that the remuneration is likely to induce Medicare or Medicaid business. You don't have to have a specific intent. It's not like, well, I intended for this guy, by paying that, I intended to induce them to get the services. You just have to know or should know that it's likely to induce that business. Again, remuneration is anything of value. It's very broad, including but not limited to waiver of copays and deductibles. If you're waiving copays and deductibles to federal program beneficiaries, then you're generally going to be violating the CMP law unless you satisfy certain conditions. It also applies to providing items or services for free or less than fair market value unless you structure the deal to satisfy certain conditions. Now, in the wake of the Affordable Care Act, they did clarify or place some limits on the scope of that inducements to program beneficiaries. Remuneration does not include waivers or copays based on financial need, documented financial need, or after failed collections efforts if certain conditions are met, including things like you can't advertise it. You don't advertise, hey, come here and we will waive your copays and deductibles. You guys are not like the local auto body shop or the glass windshield repair shop that can offer that. Remuneration does not include items or services if there is a documented financial need and certain additional conditions are satisfied, including things like not claiming the write-offs on the cost report. Certain incentives to promote delivery of preventative care, that does not violate the statute. Payments meeting an anti-kickback statute safe harbor, certain coupons on the catch-all, any other remuneration that promotes access to care and poses a low risk of harm to patients in federal health care programs. Unfortunately, we don't have a lot of guidance on what that last exception might apply to. Now, the OIG has approved certain types of inducements that you may want to offer to beneficiaries. For example, they said, hey, you could provide free or discounting items or services if it's of low value, meaning that each item or service is less than $10. So each time you give that item or service to the patient, the value of that item or services is less than $10, and the aggregate is less than $50 per patient per year. So you can't pay any one patient more than $50 per year. In addition, the government in advisory bulletins, advisory opinions, has said that free screenings, in some situations offering free screenings, that they would not violate the CMP where those screenings were not conditioned on or tied to additional services from any particular provider. So it's not like, hey, come and get this free screening. Oh, yeah, you came back positive, then here, go over here and we'll take care of it. You can't have that type of stuff in there and expect to clean up or get away from the civil monetary penalties law. They've also approved free transportation programs under certain circumstances, for example, where the transportation is reasonable and local, open to patients regardless of the payer, and other transportation options are limited. In each of those situations, though, there is not like a black and white rule, so you want to open up and look at the advisory opinions and consider whether or not you've got the safeguards in place that are going to protect you. All right, that's payments to induce referrals from the patient. Let's talk about payments to induce reduction or limitation of services that you might offer to other healthcare providers. The basis of this was when the government went to that DRG system where they're going to pay hospitals a set sum for an episode of care, the government was concerned, well, that creates an incentive for the hospitals to reduce costs, and they may want to convince the physicians to stop ordering tests or other services that the patients may actually need. So they came up with this law, which says that a hospital or critical access hospital cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit services provided to Medicare or Medicaid beneficiaries who are under the direct care of a physician. That includes gain-sharing programs, situations where you say, okay, physicians, if you save us money, we'll give you a percentage of that amount saved. Now, you're scratching your head thinking, wait a minute. That sounds like the Medicare Shared Savings Program. You're exactly right. The government can do it if it's doing it. It just won't let you do it on your own. The government created some exceptions to the Civil Monetary Penalties Law, the Anti-Kickback Statute, for gain-sharing programs under the Medicare Shared Savings Program, but outside of that, you are running risks. What are the penalties if you do this? Well, the penalties are $2,000 for each individual with respect to whom a payment was made, and any other penalty that may be allowed by law. Since that's going to create a financial relationship with those physicians, there's a potential for an anti-kickback violation and a Stark Law violation because there are no other safe harbors that are going to apply to those particular situations. Now, the OIG has periodically approved some gain-sharing arrangements in advisory opinions if certain safeguards are included, but these are done on a case-by-case basis. The government had proposed a safe harbor for gain-sharing, but it never enacted it. Instead, it kind of withdrew it, and we're still struck with this general prohibition against gain-sharing situations. If you want to do a gain-sharing program, you've got a couple of options. One is you can seek the government approval through an OIG advisory opinion. Number two is you could just decide to structure it to satisfy conditions that have been placed in other favorable advisory opinions, but remember, they're not binding on you, and the government may decide they don't like it, and they can tag you for it. Or you can become an accountable care organization under the Medicare Shared Savings Program, and you can get out of it under those ways. Otherwise, gain-sharing programs are risky. Next one, the Civil Monetary Penalties Law essentially prohibits anybody from submitting claims for payment to the government that were provided by an excluded individual. It also, or that were furnished by an excluded individual. Also, it prohibits you guys, you healthcare providers out there, from hiring or contracting with an excluded entity or arrange for an excluded entity to provide items or services payable by federal healthcare programs. So not only can those people who are excluded not get paid, not only can they not perform the services and allow you to bill for those services, but you can't even hire or contract with them. If any of the money that you're going to get and use to pay those persons, like salary or contract benefits, if that's coming from federal healthcare programs. What are the penalties? $10,000 per item or service that were improperly submitted during that period that you hired that excluded individual, treble damages, repayment of the amounts paid, exclusion from Medicare or Medicaid. So you can get excluded by contracting with an excluded individual, and the government is pretty persnickety on this. I've helped some clients on the self-disclosures, and even though they really didn't do anything wrong, they had no reason to know, theoretically, that this person was excluded, government said, we don't care. You still have to pay us back. And they've got the OIG has kind of a set formula that they have to pay back based on their percentage of Medicare and Medicaid patients, based on the salary and how much money they've been paid over a period of time. And it can easily run into the tens or hundreds of thousands of dollars very quickly. All right. Medicare or Medicaid or the other federal program will not pay the claim if the person knew or should have known of the exclusion. It only applies if you knew or should have known that the person was excluded. Well, the key there is should have known. So knowledge is not only that you have actual knowledge, but also if you had some notice of the exclusion. Well, the government publishes its list of excluded individuals or entities, its LEIE list, and it expects you to check that on a periodic basis because you're going to be held to knowledge concerning information that's in that LEIE list. Generally, if you're supposed to check that list before you hire anybody, and note, this isn't just your clinical personnel, it's any of your employees. It's your volunteers, it's vendors, it's anybody else. You need to be checking the LEIE. How often do you need to check? Well, in the OIG Supplemental Compliance Guidance, the government indicated you should do it periodically, routinely, or at least annually. But Medicaid, CMS Medicaid, said that you ought to check on a monthly basis. We really haven't got much more guidance on that. Just make sure that you're periodically checking that LEI list against all of your employees and volunteers, medical staff members, and the like. You do that by going to the government's website here. You can download that database. You can run searches that way. In addition, just like with the Anti-Kickback Statute, the Civil Monetary Penalties Law allows you to go to the OIG and request an advisory opinion. So if you want to do a deal, you want to make sure that you're not going to violate the law, you can ask for an advisory opinion and get that opinion from the government in advance. Now, just like the Anti-Kickback Statute, those advisory opinions are only binding on the parties. They're not binding on third parties. But again, if you go to the government's website, you look at advisory opinion, you structure your deal to satisfy the same requirements that are approved in another advisory opinion, the chances are probably lower that the government's going to come after you. All right, I have spoken so far about Satan's trifecta, the Anti-Kickback Statute, Stark, and the Civil Monetary Penalties Law. Bill, do you want to take it from here and talk a little bit about the False Claims Act?
Hey, thanks, Kim. You're a hard act to follow. I think you got about 75 slides covered in 37 minutes. I think it's going to take me 10 just to do 2 slides. But thanks for the opportunity to talk a little bit about the False Claims Act. And I think I want to open, if you want to go to the next slide, I want to hit bullets 1 and 3. Kim's going to return and talk about bullet 2 when I'm done with the overview of the False Claims Act. But the only history lesson we're going to give you today is that False Claims Act celebrated its 150th birthday last year. This was a statute that was passed during the Civil War when Congress was concerned about fraud on the Army by suppliers of goods to the Union Army. And it's obviously taken a much more expansive reach in the modern era than it did for probably the first 100 years. The hot action has really been since 1986 and some of the amendments to the False Claims Act in 1986. That first bullet is a fairly simple one, but there are some nuances to it that we need to talk about. The statute makes it a civil violation, a violation of the civil law, not the criminal law, as Kim said earlier, a violation that a party would knowingly submit a false claim for payment to the United States. And as you can imagine, that can come in a number of different varieties. Typically, it's going to be in the context of Medicaid and Medicare. Outside of healthcare, defense contractors are some of the bigger targets of these sorts of investigations. But if we focus specifically on, what it is, when you think about how do I ensure that my organization is never going to have any civil liability under the False Claims Act, it's important to understand how knowledge would be determined by a judge, or if there's a jury presiding. What is it that would constitute knowledge? Well, the first thing is if the government has demonstrated that there was actual knowledge that a party knew that the claim was false when it submitted it. And that one's pretty obvious. The second one is a little bit trickier to prove, but got to keep remembering, as Kim said earlier, this isn't like a criminal case where the standard is proof beyond a reasonable doubt, where you've got to convince all 12 members of a criminal jury unanimously that proof beyond a reasonable doubt exists that a person committed a crime. In the civil context, the standard is preponderance of the evidence, and a smaller number of jurors are involved in a civil case to begin with, and then you may have as few as 6, and if they conclude that essentially there's something more than 50% that suggests that the defendant is liable, then the crushing penalties that we're going to talk about in Bullet 3 kick in. That second prong, after actual knowledge of a false or fraudulent claim, the second one is deliberate ignorance of the truth or falsity of the information. So that is essentially shielding oneself from knowing what was going on in the context that the false information was conveyed to the government in the form of a claim. And then finally, the third prong is reckless disregard of the truth or falsity, kind of the same flavor as deliberate ignorance. But the bottom line is that there are going to be circumstances in which the government may not be able to prove the first prong, actual knowledge. But if they can prove that a provider was reckless or deliberately ignorant of key facts, kind of shielding the eyes from the key facts, then liability is likely to be found by a jury or if a judge is presiding the court. So that's the standard of knowledge, and so it is a civil liability that comes with an intent standard, but it is not as high a bar as you would see in a criminal case. The penalties is, I won't dwell on these because it's pretty straightforward. If an entity is found or an individual is found to be liable under the False Claims Act, there is a per claim range of penalty that can be assessed, anywhere from $5,500 per claim to $11,000 per claim. And when we say per claim, we really do mean that depending on what the investigation is able to prove, that you're not talking necessarily about a day's worth of claims or about, a year, something that has happened periodically during the year where you only get it counted one time. It literally can be, if a jury is considered, 265,000 instances in which a claim was submitted that was done with knowledge of its falsity, each of those claims can actually result in that penalty range of $5,500 to $11,000. So the liability on that is substantial, but then the real kicker, and one that leads a good number of entities to try to resolve these claims with the government, is the prospect that if one goes to trial with a defense that the claims really weren't false or there was some sort of defense, if the court or a jury decides that that is not viable, in fact they are false claims, the court would then treble those damages. And we throw that term around, but it simply means that the damages are 3 times the amount of the actual financial losses that the government has been able to prove. That's what trebling means. So the downside risk is huge, and then as noted in that final bullet, you'd be excluded from the federal benefit programs as a result of that proven liability. I didn't mention the first thing under the bullet, which is interest, but that also is something. You don't see a lot of these cases go to trial. So if you said to me, well, point to all the times when someone has been hit with $11,000 per claim and that the number of claims exceeded 100,000 claims and interest was paid and the damages were trebled. Well, the reality is that we don't have a whole bunch of examples of that, but one of the reasons why we don't is because the prospects of those penalties are so onerous, the parties settle them, and we don't typically see those sorts of things going to trial for a jury to decide liability. Kim, I think you can roll on to the next slide at this point. Okay. And, in other webinars, we've talked about the whole range of people that are on the field doing these sorts of investigations, and I won't go over them in the same detail, but the reality is that the FBI has agents that are dedicated to healthcare fraud, the HHS Office of Inspector General, the VA, the Indian Health Service. There are a number of different people who have IGs that are out there working on these cases. And then there are other entities like the Medicaid Fraud Control Units, and then the RACs and the ZPICs that are out there actually combing the data to try to determine whether there are viable claims. All of these different sources can lead to referrals to the government following an investigation that can lead to a civil case. And so this doesn't necessarily have to be something that's generated by a private party. It can be something that the government generates on its own, and all those penalties we talked about are applicable. But this slide focuses on something that one of the things that has happened with the False Claims Act in the recent era, if you will, is this idea that Congress has decided that it's effective to deputize private citizens to try to help ferret out fraud. And the people that bring these things to the attention of the government are called relators, R-E-L-A-T-O-R, as I guess is down there in the after the second dash. And these are called qui tam suits, suits brought by friends of the government. And as the slide indicates, it can be an employee, it can be an ex-employee, it can be a patient, it can be a competitor. And, you know, those of us, I had the chance to work on the government side for about 15 years, and now for the last 4 years I've seen a variety of things where it's everything from someone who used to work in an organization who's in a new organization who says, well, that's not the way they did it over there. How they do it over there is blah, blah, blah. And all of a sudden you've got a competitor that says, well, gee, they are clearly violating the way the spirit of the CPT code is written or something else. And what happens in that context? Well, the first thing that happens is that private party doesn't, the only way they're going to be able to generate any kind of financial interest is if they go to court and file a complaint, a lawsuit, under seal. That's the only way that this process is structured. They can't file it in open court. So if you somehow had a search engine up to determine whether your entity was being sued in a federal court somewhere, you couldn't do it effectively here, because when these things are filed, they're filed under seal. The only people that know of the existence of the complaint are the relator, the relator's lawyer, the government through the U.S. attorney in the individual district, and then the Office of Inspector General to whom it is referred. And they've got 60 days to then investigate the claim. They never get anything done in 60 days. These things can go on and on and on and on and on. And the reality is that if at some point the government will be forced to make a decision, it may not happen for a year or 2 years, but at some point the government decides whether it is going to intervene and take over the litigation or to decline. And in the event that it declines to intervene, then the relator has the freedom to pursue it on his or her own, and at that point it is the suit is unsealed and it progresses from there. So a quick note that there are plenty of things for which a relator is not allowed to pursue an action, and that it includes things like if the relator has determined this information because some piece of it has already been disclosed to the public, or the government is already a party to some sort of an action where this information has been disclosed. There are a number of things within the statute that don't allow a relator to go forward. The big reason why relators bring these cases, as reflected in that last couple of bullets, is that there is a substantial amount of money that can be recovered depending on what the settlement amount is or the damages determined by a jury or judge at trial are. If the government intervenes in a case and proceeds, the relator is entitled to between 15 and 25% of whatever the government recovers. If the government doesn't intervene, the relator can get as much as 25 to 30% of a successful outcome, either in settlement or at trial. And the relator also has the ability to recover attorney's fees and costs to the extent that the suit is successful. Kim, you can roll on to that last one of these slides. These are good, quick examples, and we certainly are always available to talk about your individual factual circumstances, but the 3 bullets in this slide I think are worthy of taking a quick look at. And I would focus also on that last bullet in particular. I think if you look at the OIG work plan in recent years, and I think this is just the wave of the future, quality of care is going to continue to be a focus of the government agencies. If they can find that a Medicare or Medicaid program payment is going to substandard care, where they've got a pretty good idea that certifications and promises made by entities simply haven't been fulfilled, there is a perception that there's a lot of this out there and it's largely unpoliced, and it continues to be an area where I think we've got to be careful. So these are examples of problems where entities can get into trouble, and again, we're always happy to talk about concerns and specifics if you have them. Kim, I think I'm going to turn it back over to you for the repayment component of the presentation.
All right, thank you very much. Just as a highlight of the impact of those False Claims Act cases, what the impact that they can have, that $85 million settlement that arose out of that Halifax case that I talked about in the context of the Stark Law, the court said that, hey, they violated the Stark Law. Every time they were submitting a claim to the government, they were representing that they were complying with the law. Because they were in violation of the Stark Law, they weren't in complying with the law, and that's how they got to the $85 million settlement. So you got to be really careful about complying with those statutes, because you can get hit up with the False Claims Act. And if you do that, you may have obligations under the Repayment Law. As part of the Affordable Care Act, the government removed all doubt and made it clear that if a provider has received an overpayment, that provider must return the overpayment to the federal agency, state, intermediary, or carrier, and so you not only repay, you have to also report. You have to narc on yourself. You've got to notify the entity of the reason for the overpayment. And you've got 60 days to do that. Now, you must report and repay within the later of 60 days after the overpayment is identified, or if the overpayment relates to a matter on the cost report, you have to do the report by the date the cost report is due. The bottom line is there are no finders keepers when it comes to the government. What happens if you fail to do that? Well, the knowing failure to report and repay by the deadline, hey, that's a False Claims Act violation. So all of those parade of horribles that Bill just talked about, they can all rain down on your head. It's also a civil monetary penalty law violation, so that you can get hit up with the penalties under the Civil Monetary Penalties Law. Well, what is an overpayment? An overpayment means funds a person receives or retains to which the person, after applicable reconciliation, is not entitled. For example, payments for non-covered services, payments in excess of the allowable amount, errors and non-reimbursable expenses in the cost reports, duplicate payments, receipt of Medicare payment when another payer is primary, or, here's the one for today, payments received in violation of the Stark, Anti-Kickback Statute, or Exclusion Statute. Now, when you're considering whether or not you've got an overpayment because of a regulatory violation, you have to differentiate between a condition of payment or a condition of participation. The courts have said, well, if that regulation governs a condition of payment, that we will only pay you if, then that would require an overpayment. That could be billing or claim requirements, Anti-Kickback Statute, Stark, CMP, all of those situations. On the other hand, if it's a condition of participation in Medicare, it's a licensure issue, not a condition of payment, then that does not necessarily require a repayment in those situations, like a HIPAA violation, EMTALA violation, a violation of the conditions of coverage, that type of stuff. Then you may not have a repayment obligation there. You still may be kicked out of Medicare, but it's not necessarily a repayment obligation. So make sure you know that you're dealing with conditions of payment versus conditions of participation. The government came out with a proposed repayment rule. It actually issued on February 14, 2012. I guess that was the government's Valentine's Day to all of you a couple of years ago, but it was published a couple of days later. They gave us a proposed repayment rule that tells us how this repayment process works. So while we've got this proposed rule, and it applies in the interim until we get the final rule, to report and repay overpayments, you use the existing voluntary refund process with your Medicare carrier, your MAC. most of your or all of your MACs should have a form that contractors, the MAC maintains on their website. You go in there and you use that form, and you use that to go ahead and submit the repayments. Among other things, that form will include certain disclosures. You'll have to disclose how the error was discovered, the corrective action plan to avoid a repeat, the reason for the refund, the total amount of the refund, and if a statistical sample was used, the method for the calculation. When you do that report, it's not simply enough just to do the report without the repayment. The report and repay says you're supposed to repay within that 60-day period, so you're supposed to actually include the refund. Now, if the refund is so substantial that you can't do it, you've got financial hardship, then there's a separate form that you can submit, but that additional time is not guaranteed. The MAC has to review that. You must report and return the payment within the later of 60 days after the overpayment is identified, or if the overpayment is related to the issue in the cost report, the date the corresponding cost report is due. Now, that date the overpayment is identified, that applies when the person, you have actual knowledge of the existence of the overpayment, or you act in reckless disregard or deliberate indifference or ignorance. That doesn't necessarily mean that, okay, I know I've got an overpayment, but I don't know how much. It appears to be it's the existence of the overpayment, not the amount due. So if you know that there's an overpayment, that's when your 60-day time period begins. If you have notice of a potential overpayment, you must make reasonable inquiry and with all deliberate speed to determine whether the overpayment exists. You can't just sit back and wait on this until that 60-day clock runs. In the proposed rule, they gave us some examples of identified overpayments. For example, after reviewing your records, you discovered that you were using erroneous codes, or you discovered that the services were rendered by unlicensed or excluded providers, or your internal audit reveals an overpayment, or you receive a compliance hotline tip that notifies you of possible overpayments, but you failed to take a reasonable inquiry. All of those are situations where the overpayment was identified that would trigger the 60-day time limit. Apparently, the overpayment is identified when the existence of an overpayment is confirmed or you're put on notice and you fail to make reasonable inquiry. Now, important point on the repayment rule. Just because you repay the Medicare carrier, the MAC, does not mean that you're out of the soup when it comes to STARK, the Anti-Kickback Statute, the Civil Monetary Penalties Law. The Medicare contractor has discretion. They can go ahead and they can refer you on to the government. And if they refer you on to the government, then you're going to have to deal with the government on those other issues. So when you're doing that disclosure, you've got to consider, okay, is it enough just simply to do the report and repay to the Medicare contractor, or if this is a serious issue, do we really want to go through the STARK self-disclosure protocol or the OIG self-disclosure protocol? In those situations, that may serve you better if it's a serious violation. The Medicare contractor, in order to get the benefit of the STARK self-referral disclosure protocol and to cut off your STARK liability, generally you should do the STARK self-referral disclosure protocol. Well, the bottom line is if you've got a problem, you may feel like you're damned if you do, damned if you don't. If you just sit back and you wait on it, well, you're violating the report and repay obligation, and therefore you can get hit up with additional penalties if the government ever finds out. On the other hand, if you do go ahead and do the report, you're going to have to repay. The question is just how much, and there's no guarantee that it's not going to be referred over to the OIG or the CMS for further action. The bottom line is probably to avoid going to jail or paying big penalties, I err on the side of, well, if you owe it, you probably need to repay it. The best thing, of course, to do is to practice preventative medicine and to avoid non-compliance in the first place. So here's my action list of the things you need to do to take away. First, you need to go back and look at your existing relationships with referral sources, those situations where you're giving freebies or you're contracting or giving remuneration to referral sources. Take a look at those, all of those that are up there on the screen, contracts, marketing programs, leases, all of those things. Then you need to look at them and analyze them to determine whether or not you're complying with the law. Are they structured appropriately to fit within an appropriate safe harbor, or was there an improper intent involved? Next, you need to implement a method to track or monitor those relationships, even if they're compliant now, to make sure that you monitor them ongoing. to make sure they don't fall out of compliance. Sometimes those performance doesn't match what's in the contract, which can lead to a violation. So you need to have a process for monitoring it. You really need to have a process for reviewing those relationships before you ever do the deal. So you should have a process so that any deal that you're doing with referral sources, patients, and the like, goes to your compliance officer or a healthcare attorney, somebody who knows what they're doing, that they can look at this and say, yeah, okay, that complies with the law. You need to make sure you've got an effective compliance program. One is to make sure that people comply. It'll help people actually comply. Two, if the government ever comes in there and does an investigation, the first thing they're going to want to know is if you had an effective compliance program, because if you did and somebody just screwed up, they'll go easier on you. Then you need to train your key personnel regarding your compliance and document that, because if you can show you have a compliance program, you trained your people, and somebody just went rogue, then the government will go easier on you. Above all things, if you've got a suspected problem, do not do this. Remember, it may not have been a false claim when you originally submitted it because you didn't know any better, but once you know there's a problem and you fail to report and repay within the 60 days, that turns it into a false claim and can subject you to all those other penalties. We've talked about the federal laws. Remember that for most of this stuff, there are also state equivalents, so don't forget about the state laws. Some additional resources. The government maintains a very helpful website dealing with compliance issues. Among other things, it's got a Compliance 101 series of videos that talks about these issues that you could use to train your staff. The government's issued compliance program guidance. We've given you a sample one. The government's issued its advisory opinions, special fraud alerts, fraud bulletins, and other materials that can help you identify those issues. As I mentioned at the beginning, we've also done specific programs on the CMP, STARK, the anti-kickback, report and repayment. Those are available for download on our website. They're in more detail, and you can use those to train your people. That is it. That brings us to the end of our program today. We have covered a lot of information. Hopefully none of this was new, but it will serve as a reminder and inspire you to go back there and making sure that you're complying so that you don't have to deal with the government when they come knocking on your door. Thanks very much. We appreciate it. If you've got questions, feel free to shoot either Bill or me an email. We'll do our best to respond to those. Otherwise, we appreciate your participation as always.